Hey YouTube family and GN subs, hope you're doing well. I have some great updates for you today. We're going to talk a little bit about the Supreme Court and a recent decision and its impact on immigration. Really good stuff. I also have an update on the 212D3 waiver. I call that the magic waiver. I'm going to tell you all about it. And also we have some really good news regarding a recent case I adjudicated. It's called Matter of Quilantan. We're going to talk all about that. All right, we got a lot to get to today, so let's get at it. All right, so the Supreme Court just made a very important decision today. Let me break it down for you folks, all right? Simple civics lesson, but it has real relevance to what's happening today. We have three co-equal branches of government, right? Executive, Congress, and judiciary. What's been happening with the administration is they are trying to concentrate all power with the executive. Congress has what's called the power of the purse. They indicate exactly how money is to be spent. Congress said money should be spent with the USAID. You're probably familiar with the case. And the executive comes in and says, no, we're going to withhold $2 billion of spending that Congress allocated. Is that proper? Well, what we do is we have to look at the Supreme Court, and the Supreme Court recently, last week, rejected the executive order and said, no, it is unlawful. And they, in essence, allowed money to be paid as Congress intended. Okay, that's the simple version. Why is this so important in immigration, folks? It's very important in immigration because now we see that the judiciary is going to check the executive. That is awesome. We thought maybe that wouldn't happen. And if that didn't happen, we'd be in a real constitutional crisis right now. So we have some really important immigration cases that are coming up and going to the Supreme Court. My guess is that the Supreme Court is not going to accept all unlawful executive orders by the administration. That is really good news, folks. I was so excited to hear the decision of the Supreme Court that put the check on the executive, and I think we're going to have a lot more of this, folks. I'm going to keep you updated, okay? All right, let's talk about the magic 212D3 waiver. We have some new guidance. I think it's ultimately going to be good. I'm going to break it down for you. A 212D3 waiver waives grounds of inadmissibility. You have health-related grounds of inadmissibility. You have criminal grounds of inadmissibility. You have a 10-year bar for the dreamers. So where you're not able to obtain a non-immigrant visa, this is for non-immigrant visas. When you're not able to obtain a non-immigrant visa based on one of these grounds of inadmissibility, you can apply for a waiver and you waive that ground of inadmissibility, okay? I have a really good video on the magic 212D3 waiver, and this is a little update. Now, so what is the update? The update basically is that previously, State Department had to recognize prior decisions with regard to your 212D3 waiver. So what that meant is if your 212D3 waiver was denied for whatever reason, subsequent times, that waiver will not be approved. They have to go by certain rulings that came previously. So the new guidance, and I put a link in the description box below so you can go to it and you can check it out. You can read it. It's pretty simple stuff. Consular officers no longer have to abide by prior decisions. They will make decisions independent based on the facts, based upon the application at hand. That is really good. So, if you've had bad luck in the past, put the waiver back in. You will be surprised that it may be adjudicated in a positive manner. And again, you can cite this new guidance. You can say, look, my case was denied previously, but according to this guidance, here's new facts, here's new evidence. Please adjudicate this independently from any prior decision, and hopefully you'll get a good outcome. All right, Matter of Quilantan, link in the description box below. Check out this case. Just as background, I've done some videos on Matter of Quilantan. Go check them out. Really good stuff. Basically, if you're at the border and you're coming through and immigration waives you through, even if you don't have proper documentation or a legal method by which you were entering, that is considered a lawful entry. And that has really big ramifications for adjustment of status. For example, if you have a lawful entry, even if you're illegal for years and years and years, and you've engaged in unlawful employment, if you made one legal entry, you can adjust your status here in the United States under 245A. I've used matter of Quilantan many, many times, and the good news is that I just had a case approved under matter of Quilantan here in the LA field office, immigration. Good stuff. It was a case that had been pending for quite some time, and the previous attorneys didn't understand how to adjudicate this case. Well, I did. I put together a matter of Quilantan case. I had a detailed statement on the method of my client's entry into the United States. The district office approved it. I've been reading basically that the district offices are not approving cases under Quilantan. That is wrong, folks. They are approving cases under Katon. I just had one approved. That is good stuff. So if you have someone that you know, you might want to mention to them or share this video with regard to matter of Katon. Go back to my library. I got good stuff in there and check out the case and all the details with regard to matter of Katon. It could be really, really helpful in a case where you want to file an adjustment here in the United States. All right, finally. What's going on with this spectacle, this administration, right? It's a big spectacle. It's a lot of show. It's all about things getting in the media and things blowing up. Social media, things going viral. Let me tell you, folks, stay calm, right? I tell my clients time and time again, how's that wall coming along down south that Mexico paid for? It's nothing, right? It was just a big spectacle. All of this is the same. With regard to immigration, our laws are promulgated by Congress. The executive cannot promulgate rules and regulations with regard to immigration. That's what's happening. 3 separate branches of government, folks. They are equal. They are 3 equal branches. They have all equal power. We're going to see it at play, and we're going to continue to bring you good news, folks. And hey, YouTube family, GN subs, thanks so much for watching GrayLaw TV. Please click below, share, like, and subscribe, and we'll see you next time.